Welcome, everyone. Thank you so much for being with me today. I'm Shanna Welsh-Levin of SoCal Realty Law. I've been a real estate attorney for going on 20 years, over 19 years. And I am the president of Amicus, which is a nonprofit 501c3 organization that seeks to house women and women with children. I'm also in addition to being a licensed attorney in the state of California, I'm also a licensed real estate broker in the state of California. I have, worked on various different projects over the years, and hopefully I have a lot to offer you today. I annually am asked to do a new laws presentation for the North County Bar Association and other organizations. And so you're my test group. And so, any feedback afterward is also welcome if you think that I could have touched on certain areas that I missed or if I missed any new laws that you were interested in. So today we're going to do what landlords need to know about new laws in 2023. Most of the information today relates to residential real estate and what residential landlords need to know. I have left out significant developments in the law relating to mobile homes and mobile home parks. And there is a lot of cases and other laws relating to commercial tenancies that we just don't have time for. So we're going to focus on residential. In particular, we'll review the Chula Vista ordinance, the new municipal code that was just passed and goes into effect March 1st. The statewide enforcement of local ordinances. So the state has started commenting and adjusting things with regard to local ordinances. We'll talk about developments in tenant harassment laws and prevention, domestic violence, prevention of eviction by tenants who have been victims of domestic violence, discrimination, security deposits, habitability of dwellings, premises liability for landlords, and more. So there's a lot to cover today. Let's get started. Starting with Chula Vista Municipal Code. So we have this new chapter 9.65 of the Chula Vista Municipal Code, which it's easier to say what it does not apply to. It defines itself by saying it does not apply to certain types of property. And you'll find that if you're familiar with the Tenant Protection Act of 2019, the California Rent Cap Just Cause law, there are a lot of similarities to it. So the Chula Vista Municipal Code new ordinance does not apply to owner-occupied homes, including accessory dwelling units, ADUs. It does not apply to duplexes where the owner resides in part of the duplex at the beginning of the tenancy and continues to reside there throughout the rest of the tenancy. It does not apply to single-family residences or condos if that property is not owner-occupied, as long as the owner is not a real estate investment trust, a corporation, or an LLC, where a corporation is the member of the LLC. So basically, single-family residence owned by an individual, or it can be an LLC if the individual is the member of the LLC, like it's, for estate planning purposes as opposed to business purposes. And in order for a single-family residence or a condo that's not owner-occupied to be exempt from the Chula Vista Municipal Code chapter, the landlord has to provide the tenants with notice of that exemption. So this is similar to the California Tenant Protection Act in that the owner who may be exempt isn't exempt until they claim the exemption. For new leases in the city of Chula Vista after March 1st, 2023, the exemption claim has to be incorporated into the new lease. So one of the free resources we'll send out with the video is that language that needs to be incorporated in the lease. It can be done as an addendum to the lease. As of today, what you can do for existing tenancies is to just send the tenant a notice. If the lease predates March 1st, 2023, you just send a notice. Other exemptions apply to various classifications such as mobile homes, hotels, nonprofits, dormitories, affordable housing, and vacation rentals. So the new ordinance is only applicable to things like residential complexes and properties where they're not owner occupied and they haven't claimed the exemption. Okay. Oops, wrong way. So the Chula Vista Municipal Code now defines a substantial remodel in a way that is different than other laws. So if you're focusing on, if you have property in Chula Vista and you're focusing on how this law applies, you need to specifically read the substantial remodel definition. I find that many landlords who need to do a no-fault eviction are doing it because of the need for substantial remodel. They've just purchased a building, they're rehabbing it. And so compliance with this particular definition is difficult. It is a broader, it's not a broader, it's a more specific definition of substantial remodel. Any structural, electrical, plumbing, or mechanical system is being replaced or substantially modified. The cost of improvements is greater, or it's equal to or greater than $40 per square foot of the residential rental unit. So a 2,000 square foot residential rental unit must be receiving repairs of $80,000 or more, costing $80,000 or more in order to fall under substantial remodel. Also, a permit must be required and obtained from governmental agency. It doesn't say that you have to obtain the permits prior to terminating the tenancy, but it's a good idea to actually have that process taken care of so that you have the proof in place. And also that the substantial remodel is necessary for the residential rental unit to be vacant for more than 60 days in order to complete the improvements. The statute goes on to state that cosmetic improvements alone, no matter how expensive they are or how long they're going to take you, is not alone a substantial remodel. So they specifically say things like painting, decorating, flooring replacement, counter replacement, minor repairs do not qualify as substantial remodel in Chula Vista. Additional requirements upon termination of the tenancy in Chula Vista for no fault just cause. There are two different requirements depending on the status of the property. One is a residential rental complex. A residential rental complex is defined here as 3 or more rental units. In those cases, for a residential rental complex, the landlord must issue a notice to the tenant stating 3 things: the basis for the eviction, the relocation assistance, and the right of the tenant to receive a future rental offer. The calculation of relocation assistance for the rental complex is different than for a not residential rental complex, like a single family residence. So the relocation assistance amount for the rental complex is 2 times or 3 times the U.S. Department of Housing and Urban Development small area fair market rent amount for the zip code. You can look that up online. If you just Google that name, the list will come up so that you can figure out what that fair market rent is. The relocation assistance is 2 times for most people, but if the tenant is disabled or elderly, then it's 3 times. The complication here is I've gone around for years telling landlords to avoid asking tenants about their disabilities and their age, because then a tenant might use that as ammunition against the landlord to say that they were discriminating. But this ordinance says that if you do know about a disability or an elderly tenant, you have to give them additional relocation assistance. So the question is, should you be asking this? Are you obligated to ask? Well, the statute doesn't say anything about whether you need to find out that information. And so it's a little bit unclear. So then for units that are not residential rental complexes, but are not exempt from the ordinance, They have to issue a notice to the tenant stating the basis for the eviction, the relocation assistance, and the relocation assistance for these properties is only 1 month of the actual rent. So it's a significantly less than the rental complex. Oh, and I forgot to mention, for the rental complex, the other thing that needs to be in the notice is the right to receive a future rental offer. And that's explained in the statute. I don't think we have time to go through what that means, but it's basically if you put the property back on the market within the next 2 years, and the tenant has given you contact information and expressed interest in taking occupancy after the remodel is done, or whatever is going on, then the landlord is obligated to offer that past tenant the right to re-rent the property. The statute requires notice to the city of Chula Vista no later than 3 business days after the notice is served. Now, I did not have time to go to the Chula Vista city website, but part of the ordinance says that the administrative departments of the city will have to issue additional rules for this. And so it's not clear to me right now where you would send that notice to the city of Chula Vista. At this point, if they don't have something specific on their website, I would just mail it to whatever their main post office box is. And further guidance on if you use withdrawal of the property from the residential rental market as your no fault just cause eviction reason, the withdrawal of the property has to be for 2 years. So you can't re-rent it for 2 years under the statute, or else you'll be liable. So a couple other notes on this. This is effective March 1st, 2023, and would expire January 1st, 2030, unless it's extended. The enforcement penalties for violating this municipal code statute include that either private citizens or the city attorney of Chula Vista may enforce the rules. There are statutory penalties of $2,000 to $5,000 for each violation. The city attorney or the tenant's attorney may receive an award of attorney's fees if they successfully enforce the ordinance. It is an affirmative defense to any eviction, and there may be criminal penalties. So it goes well beyond what the rent cap and just cause statute provides for enforcement. Okay. The city of San Diego is thinking about following suit and doing similar things with the city of San Diego fair renter ordinance. Right now we have, the current law is the fair renter ordinance that after a tenant has been in a residential property for 2 years or more, you have to provide just cause for their eviction. I suspect that the new proposal by the city they are focusing on no fault evictions. It would require relocation assistance and longer notice periods for no fault evictions. All right, so in the state of California, we have a bunch of new case law and statutes that speak to all of the local ordinances. If you've come through this whole process from 2020 till now with COVID changes in the law and all the problems with housing in the state of California, there are all these local ordinances which make us crazy. It makes it so hard to keep track of this stuff. That's what justifies my existence, is just trying to keep track of all this stuff for you guys, and then presenting webinars like this. But keeping track of them is challenging, and there's more than you could ever include in one webinar. So the state has started to inch in on regulating the local ordinances to the extent that it's able to. There's this case, Ballinger versus the city of Oakland. So the city of Oakland issued an ordinance requiring relocation fees, and with many of these regulations, there was a constitutional challenge raised by this plaintiff, Ballinger, claiming that this ordinance violated his constitutional rights by making him pay relocation fees. And the court in the Ninth Circuit, the Ninth Circuit is the Court of Appeals. So there was a trial court that heard this case and decided that it was unconstitutional. And then this went up on appeal. I'm sorry, you know what? I need to review the cases more carefully. But basically, the Court of Appeal held that the ordinance requiring relocation fees does not violate constitutional rights. And so that case law will carry through the state and help all of those local ordinances to be validated and avoid other constitutional challenges. Then we have a new government code statute, a couple of them that identify the maximum allowable penalties for short-term rental ordinance violations due to rentals that cause infractions that pose a threat to public health or safety. So then local jurisdictions also are ordered to establish a process for granting hardship waivers to reduce fine amounts. There were these heavy fines being issued by certain local jurisdictions, and the state came in and said, here, there's a maximum that we're going to allow you to enforce. A new case, Duncan versus Kahagi, I have no idea how to pronounce it, but the basic holding in this, and we'll go into this case a little bit further because it is a very interesting one. The holding is that treble damages for wrongful eviction in the huge amount of $2.7 million were neither confiscatory or violative of due process. So what that means is that there was a constitutional challenge to the amount of the damages that were awarded by the trial court. And in this case, the trial court had even knocked back some of the damages that the jury had awarded. But ultimately, the large amount of damages were found to be constitutional. This is a case from San Francisco where they have some differences in the law with regard to rent control. So this may or may not be applicable to us here in San Diego and Southern California. So with regard to tenant harassment, the Chula Vista Municipal Code also adds some regulation for anti-harassment and retaliation against tenants. It prevents landlords and their agents, employees, contractors, etc., from acting in bad faith toward a tenant for doing any of the following. So failing to provide housing services, those are, things like utilities and other things that go along with the tenancy, services that go along with the tenancy. Failing to provide repairs and maintenance, or to exercise reasonable efforts and diligence to make repairs and perform maintenance. It prevents the landlord from abusing the right to lawful access. I put a note here, inspection versus making repairs. So the right to lawful access is defined by statute and can be modified in your lease. The standard language and the statute do not provide the landlord with the right to enter for simply the purpose of inspecting. It only allows the landlord, well, one reason it allows the landlord to enter is for the purpose of making repairs. And so to the extent that an inspection may be necessary to determine the repairs that need to be made, it has to be in the context of actually making repairs. So abusing the right to lawful access could include claims by the tenant that the landlord has been entering the premises to make random inspections just to look at the property. And you see further down on the list, interfering with the tenant's right to privacy, including photographing portions of the unit that are beyond the scope of lawful entry or inspection. So when you issue that notice of entry, you have to say why you're entering, and you should say when you're entering and who is entering with you. And if you go outside the scope of that, then you could be liable for abusing the right to lawful access. So the new ordinance in Chula Vista prevents verbal abuse and defines verbal abuse as words that are offensive or inherently likely to provoke immediate violent reaction. taking possession of the property based on false notices to terminate the tenancy. So this means that the landlord is trying to terminate the tenancy and has issued notices to support an eviction that are based on false information or not supported by the facts. It does protect attorneys like me from issuing notices based on things that I'm told. So, you know, if my landlord client comes in and tells me such and such happened, I'm going to rely on what they say. I'm going to draft a notice, but based on what they say, and if that turns out to not be true, I'm protected under the ordinance. Let me pause here. I forgot to mention at the beginning, I'm not giving legal advice in this webinar. In fact, I'm giving you a lot of information based on new laws that I myself am not 100% certain about their application and about, you know, all of the way that they've been created or the reasons that they've been created. So I just want to remind you all that if you have a specific situation, and it sounds like I'm talking about the particulars of your specific situation, it is important that if you have legal questions, you follow up with an attorney and do a one-on-one confidential consultation with the attorney to make sure that you're getting appropriate advice. So take all of this with a grain of salt, that these are general statements of the law and cannot be assumed. You can't assume how they would apply without getting proper legal advice. All right, moving on. So the Chula Vista Municipal Code also regulates harassment with regard to interfering with the tenant's right to quiet use and enjoyment. That kind of goes along with abusing the right to lawful access, and it can also involve a lot of other kinds of behavior by a landlord or their agents to interrupt the tenant's use and enjoyment of the property. Refusing to accept lawful payment of rent could be a violation. So up to a certain point in the eviction process, if a tenant attempts to pay rent and the landlord has not terminated the tenancy, the landlord has to accept a rent. There's a new exception under the law this year. We'll get to that, but basically it would be harassing the tenant to refuse to accept the lawful tender of payment. And then it forbids retaliation against tenants who exercise their rights under this ordinance. So the Duncan versus Kahagi new case holds treble damages for wrongful eviction of $2.7 million were not confiscatory or violative, meaning that they are constitutional. The holding in this case is interesting because the landlord had issued notice to the tenant to vacate based on withdrawing the property from the, the notice was based on the landlord moving into the property. This is a no fault just cause eviction. Meanwhile, throughout this relationship, the landlord had deprived the tenants of housing services, including hot water, and abused the right of entry. The landlord violated the right to quiet enjoyment with the intent to cause the tenant to vacate. And then the court also found the lack of good faith for the no-fault eviction. Specifically, the landlord owned another home that was closer to her work. Her driver's license and car registration listed another address. Her other address was listed as the primary residence for the purposes of a mortgage refinance, and the landlord failed to move in when she told the rental board she would, but she testified that she did eventually move in. So they're a little stricter in San Francisco, but you can see how some of this would apply here if you use the reason of the landlord moving in as the reason to terminate the tenancy, and then you did some of these things, it would apply equally here as it does in San Francisco. So there are special protections for victims of domestic violence, and there is the Federal Violence Against Women Act. The law has for a long time protected victims of domestic violence from eviction, from a no-fault eviction. because arguably a no-fault eviction could be secretly based on the fact that they've had some, some legal troubles or some issues with domestic violence at the property. SB 1071 provides that a landlord is liable to the tenant for actual and statutory damages for terminating a tenancy where the tenant or the tenant's household member or immediate family member is a victim of domestic violence or sexual assault, stalking, or other specified crime. And it specifically makes this an affirmative defense to an eviction. So the new language, the new legislation helps clarify the law for us. There's also a new case, the Massian versus Flores case, that provides some guidance on the requirements for documentation of domestic violence when the victim claims that they're protected. The question is, what kind of documentation do they need to be able to provide to prove that they were a victim and to prove that they're protected? And this case says that the documentation can consist of only a police report narrating domestic violence, an incident that's based, if the police report is based solely on the tenant's statements that do not name the perpetrator, do not indicate the relationship between the victim and the perpetrator, and only document one of multiple incidents upon which the landlord may be aware of. So this protects the victim by giving them just the minimum requirement to prove that there was an incident. And it broadens the protection by stating that all they have to provide is the police report with a narrative. The Violence Against Women Act disclosure relates to Section 8 housing, because Section 8 contracts are funded by federal funds. So the U.S. Department of Housing and Urban Development provides some authority and now requires that Section 8 tenants must receive a notice of occupancy rights and a HUD-approved certification form when you issue notices to terminate their tenancies. The form can be found fairly easily online, and I would like to also provide this to you as one of the free resources with the video. So I'll get a copy of that. We have it. We have to use it fairly often when we do Section 8 evictions. All right, short-term residential occupancy. Recall that in November, I did the webinar all about short-term residential occupancy. In November, all of those applications were due for the Tier 3 and Tier 4 licenses, and those have been issued. To my knowledge, they've issued them all, and they did not meet their quota for Tier 3 and 4 for those permits. And then the Tier 1 and Tier 2 in the city of San Diego are still ongoing. You can always apply for them. I'm not sure if they've reopened the application portal for the Tier 3 and 4 yet. California law has also started to inch in on some of the local short-term residential occupancy laws by, as I mentioned before, regulating the amount of the penalties that the local authorities can issue against landlords who have violations relating to health and safety. And then we have Government Code 25132 and 36900, which those are the statutes that provide those maximum penalty amounts. And in the city of San Diego, the short-term residential occupancy permits must be in place. You have to have one by May 1st, 2023 in order to continue to do short-term vacation rentals. So make sure that if your property is in the city that you've applied. Security deposits, new law is Civil Code Section 1950.6, which I believe this is just an amendment to an already existing law. The law provided that it created this thing called a reusable tenant screening report, and the law has been adjusted to define the term reusable tenant screening report and require that the report contain certain specified additional information. And it prohibits a landlord from charging the applicant a fee for the landlord to access the report, or quote unquote application screening fee. So if you do a lot of tenant screening, this is something you want to be aware of. And it does not consider that fee to be part of the security deposit, so it can be charged in addition to the security deposit. Okay, so habitability is always an interesting issue in California, because tenants who claim habitability can create problems for us when we're trying to terminate tenancies. The law requires that the landlord receive notice and an opportunity to cure. And so, you know, there is a defense to the landlord when we get wrapped up in a habitability issue. The tenants often have the problem of gathering the evidence, because it's hard for a tenant to prove the habitability issue if they don't want to spend the money to document it, or to get the appropriate professionals to come out and inspect it and confirm the problem. So in this new law, the adjustment to the law went into effect July 1st, 2022. And I believe I've already seen the effect of it, because I think that the city of San Diego is being more responsive to these complaints. The law requires a city or county that receives the complaint regarding potential lead hazards or substandard buildings. They must inspect the building. They have to document the applicable violations, and then they have to put it in a report and advise the owner or operator of each violation, the action required to remedy the violation, and then they schedule a re-inspection to verify correction of the violations. And there are additional requirements that apply. So that being a new law, it's interesting because it's a law that requires the government agency to do more. I always thought that, you know, personally in my experience, it was difficult to have the authorities come out and inspect unless you said certain keywords like sewage leak or electrical, you know, electricity or something. But now it's lead hazard violation or a substandard building. So, okay, landlord premises liability. We have a bunch of new cases, and I'll try to go into as much detail as I can, but the general rule, the existing rule, is that the landlord is required to exercise due care. So we have this new case, Montes versus the YMCA of Glendale. The basic holding is that the landlord was not liable for the tenant falling off the roof. So in this was a wrongful death action. The tenant died after he had gone up on a steep sloped roof covered with brittle, broken, slippery, and unstable Spanish tiles. Although there was an open and obvious risk from the roof, there was no necessity or other circumstance that made it foreseeable that the resident, who had been drinking and eaten a marijuana brownie earlier in the day, would choose to encounter the obviously dangerous condition. So that's it. I mean, that says it all. If you're a landlord, you don't have to worry about someone drinking and eating brownies and going up on your roof. I have given the advice before, though, that if the roof is very low and it's very easy for people to get on the roof, that it is a hazard, and so things can be done to try to reduce the liability from such hazards. Another case, Hussein versus Club Demonstration Services, involves one of those Costco contractors that, you know, has a sample that they're handing out, or they're selling something on the floor of Costco. So the independent contractor operated a food sample table inside Costco, and the court held that they had a special relationship with Costco shoppers and invitees that gave rise to a duty of care that extended to the entire store, not solely the 12-foot work area defined in the contract. So the contractor became liable to the entire store. And I wrote this a little bit wrong because it's not that Costco was liable for the entire store. Of course they were. It's that the Costco contractor was also liable to the entire store. Another case, Jane I.L. Doe versus Bright Star Residential. The holding is that the landlord is liable due to a special relationship to residents at a home for disabled individuals. In this case, a resident at the home for disabled individuals was sexually assaulted by a handyman who was hired and supervised by the home, and that the home had a special relationship, that the resident had a special relationship with the home and the homeowners. So the home and the homeowners were liable for the actions of the handyman and the events that had happened, the assault. And then the case of Caney versus Custance. In this case, it was not, this is not the final holding of the case, but the issue that was decided was whether the landlord had actual notice or reasonable time to discover dangerous conditions and an opportunity to cure, that was a question of fact that needed to be heard by the jury. This holding makes it more difficult for a tenant to pursue a landlord for habitability issues and premises liability because now the landlord can show that whether the landlord had actual notice of the dangerous condition, reasonable time to discover it, or an opportunity to cure it is a question of fact that has to go to the jury. Okay, COVID notices. There's not a lot of new COVID law, which is great. There's no more state of emergency. For the most part, any notices that we're issuing now don't have to comply with any of the COVID requirements unless they are for rents that were due during the COVID time period. So for someone like me who has to navigate this, these are nice adjustments to the law because they are clarifying the language in the notices and other provisions that, you know, it's all very technical, but basically they've drawn a bright line between notices served before April 1st, 2022 and notices served on or after April 1st, 2022. And then if there's a local ordinance, which we don't really have in our area, but a local ordinance that defines a repayment period for COVID related rental debt, that it's adjusted those dates, and the repayment period cannot go beyond August 31st, 2023. Some new laws with regard to discrimination, affordable housing, and support animals. So equal access. So Health and Safety Code 17-929 now provides equal access under the State Federal Employment and Housing Act. Equal access protections apply to affordable housing unit occupants in mixed income multifamily structures. Those occupants must have the same access to the common entrances, areas, and amenities as the market rate housing unit occupants, and the structure must not isolate the affordable housing units to a specific floor or an area of a specific floor. I'm not sure what events were taking place that resulted in this, but I think it speaks for itself that, you know, people living in a building, if you have a certain number of affordable units, they have to use the same doorways. They can't all be on the same floor. They have to be interspersed throughout the community. And, you know, you could designate certain affordable housing units as they come available instead of having only certain ones designated as affordable housing units. Health and Safety Code. No, that number is not right there. So it's 122317. That is right. Yeah, okay. And 122319.5 relates to the definition and the application of emotional support dogs versus the rights and privileges given to guide dogs, signal dogs, or service dogs. Basically, the Health and Safety Code distinguishes between an emotional support dog as defined in the health and safety code, and a guide, signal, or service dog. This arose because people were selling emotional support animals and stating that the emotional support dogs or animals would have the same rights and privileges as someone who's selling guide dogs, signal dogs, and service dogs, but they actually have different rights. Guide dogs, signal dogs, and service dogs have specific training and certification, whereas emotional support animals do not. And so this just clarifies the differences between the two. And then we have a new case, the Southwest Fair Housing Council, Inc. versus Maricopa Domestic Water Improvement District. It provides some clarification on how a plaintiff may state their prima facie case on disparate impact discrimination under the Fair Housing Act. So the plaintiff has to demonstrate, number one, the existence of a policy, not a one-time decision, but an ongoing policy that is outwardly neutral, but two, has a significant adverse and disproportionate effect on a protected class, and three, quote unquote, robust causality that shows that the challenged policy caused the disproportionate effect. It's technical legal mumbo jumbo, but it's important clarification for anybody who's involved in a case like that. We have some new developments in the Rent Cap Just Cause Tenant Protection Act of 2019. I call it lots of different things depending on the day of the week and how I feel that day. RCJC is the easiest thing, Rent Cap Just Cause. This case of Lara versus Mancini was a 2021 case, and its holding relates to subtenants. So when the landlord terminates the main tenant, the tenant who initially leased the property, when the landlord terminates the main tenant's lease, the subtenants have no legal right to remain in possession of the property. And this is particularly involves a default on payment of rent. So then also the landlord was not obligated to give the subtenant an opportunity to cure. As you know, as many of you probably know, when you issue a 3-day notice to pay rent or quit, the landlord has to accept the payment of rent within the 3 days. And once the 3 days passes, the landlord no longer has to accept the rent. If the subtenant offers to cure the rent, the landlord is not obligated to accept the rent from the subtenant. And we might use this case to argue that for other cases of, cure, breach, or quit, if it's a subtenant, the landlord doesn't have to accept the cure from the subtenant, but only from the main tenant. And then where the subtenants or the tenants or sublessors lease is forfeited, the landlord is entitled to possession against the subtenants. So this is also nice clarification about cases against subtenants. And then in unlawful detainer litigation, we have a new form summons. If you use the old form summons, you may end up at trial and find out that your whole lawsuit is invalid and needs to start over again, or at least be reserved and start again. And then we have the case of Premerman versus White. Oh, by the way, there are other new forms. So it's the summons, but it's also the request for entry of default, and the request for entry of default judgment form has been updated. So if you're going through the default process, you have to make sure that you're also using those updated forms, or else the clerks will kick back your paperwork and start again. The eviction process, especially the default judgments, are taking a ridiculously long time. I think we have court judgments and clerk judgments. The court judgment is where we're asking not only for possession, but also money for an eviction. And then clerk judgments can be entered by the clerk if they're only for possession and not for money. So the clerk judgments move faster than the court judgments. The clerk judgments, if you submitted your paperwork on, I think it was October 1st. I got an update yesterday from my paralegal. If you submitted your paperwork on October 1st or before, then you should be getting your judgment. The clerk is working on your judgment. So November, December, January, they're 3 months behind on clerk judgments. That's how long it's taking to get a default judgment against the tenant who did not respond to your eviction lawsuit. For a court judgment for money, they are currently working on September 1st. If you submitted your paperwork on or before September 1st, you could expect to get your judgment pretty soon. So they're 4 months behind on court judgments. So that's all I have for you. Well, I guess, wait, what else do I have? So for the service of process, there's a little bit of clarification on serving a tenant through commercial mail receiving agency. If the landlord showed no reasonable diligence in first attempting to personally serve the defendant, that service would be invalid under CCP 415.20C. And that's the Kremerman versus White case. And then CCP 367.75 just puts into the statutes how the court may conduct conferences. The courts are allowed to continue to conduct conferences, hearings, and proceedings through the use of remote technology, absent a showing by the opposing party as to why a remote appearance or testimony should not be allowed. During COVID, I had a trial conducted by the Palm Springs Riverside Court by telephone, which blows my mind that they would even conceive of that as a valid way to conduct a hearing, but that happened. And it was very difficult. And I think it was a disservice to the client because you can't present evidence over the telephone. Okay, so then one other note I want to make sure that I have told you about is we are currently under a new state of emergency due to flooding. The government of California issued a statewide emergency on January 9th. This does trigger the Penal Code Statute, Section 395, which caps rent increases to 10%. And that includes if you're re-renting an apartment, not just increasing rent on current tenants, but the tenant moves out and you have a new tenant coming in. Until the state of emergency is over, you are capped at 10% on the increase for the new tenant as well. So the cap lasts for 30 days from the issuance of the state of emergency, unless the state of emergency is extended. And so February 9th would be when the application of the statute and the cap would expire unless the state of emergency due to the rains is extended. All right, so that is all I've got for you today.